representing the mother and appellant in this matter. It is an appeal from adjudication and disposition of the juvenile court regarding young child A.S. The child was found dependent pursuant to 215104 subsections C and D, and then was at disposition placed in the custody of Summit County Children's Services and removed from the parent's home. Mother is here appealing both the adjudication and the disposition as having been removed from that home, that even if adjudication were to be found and dependency were to be maintained by this court, the removal of the child is in the best interest of the child was against the manifest weight of the evidence, was an abuse of discretion as against the manifest weight of the evidence here. To start with adjudication, as the court is aware, there are two subsections here. The subsection C is broad clause stating that there is a condition or environment such to warrant the state in the interest of in the best interest of the child, assuming guardianship of that child. In subsection D, which is applicable here as well, that if there's a sibling of the child who's been previously adjudicated as abused, neglected, or dependent, and the second prong of that would be that the conditions that led to that finding continue and place the current child at a risk of abuse or neglect. I would contend that the agency has failed to demonstrate by clear and convincing evidence that either of those standards were met and that the trial court abused its discretion in adjudicating the child's dependent. Regarding subsection D, first, it is undisputed that there were other siblings in this matter, and those children have been adjudicated as abused and dependent, I believe, is the holding out of the other children's case. What is also undisputed is that there was no finding by the trial court that the conditions would lead to a finding that those conditions for the prior children would place this child at risk of abuse or neglect. That's a clear distinction. There has to be a risk of harm or of either active or passive harm for the child based on those prior findings. As the state has indicated in its brief, the testimony that the concerns raised in the original complaint regarding the other children, if there's testimony that those conditions continue to exist, then that would be sufficient evidence. I will tell you that the testimony given at adjudication does not indicate that. In fact, the prior children had been returned to the home and were residing in the home at the time because many of those issues had been addressed. The prior concerns that led to the complaint in the older children's case were those of domestic violence and abuse toward the older children by their father, who is not the father of the child in this case. That child is no longer, that father is no longer the current father. There are no allegations of physical abuse here. There are no claims that the young child that she was at risk of physical harm. This solely progressed as an abuse case, as a dependency case here.
What about the contentions in the sibling cases that said that the parents hadn't done what they were required to do in the case plan of the companion case?
And in that case, the mother had clearly been participating in that case plan to the point that the children were returned home in that case. And subsequently, part of the disruption in this case and in that prior case was the animation, and you'll see this continually referred to, that the older son is very active and an active child, and that child is, despite his young age, was showing outward behaviors relating to the abuse and trauma. And the concerns, while I think not even in this case sustained toward the young child, toward the infant, arise out of his behaviors. And that child was removed from the home in a disruption on that earlier case. And that I think,
Is
and
it permanently removed from the home?
at that time, no. Right now, there is a, to be clear, that case has resolved as legal custody to kinship placement, to kinship relatives. And that decision is currently pending appeal, and I'm not handling that. But regardless, the court did not make that finding. It would indicate that their judgment entry is flawed in that regard, at a minimum. I think that there would need to be a review and remand for those considerations to properly be before the court. But I think in reading the case and reading the transcripts here, what you will find is that the infant and the parents were demonstrably capable and demonstrating that they were taking care of this child and that there was no risk of harm or the condition or environment that necessitated the agency's involvement with this young child. Especially at the time of the refiled complaint after the older two children had disrupted and been removed. And again, I think it's relevant that there is a different father here, and a different father who is in the home. The home is repeatedly, I think by almost every one of the agency's witnesses, referred to as small but appropriate for the family. And I think that you will find that the caretakers from Fast Track are in the home, the caseworker herself refers to that, and it's almost a repeated a litany, that home is small but appropriate. There is no instance that can be pointed to of actual physical harm to this child, of an actual risk of harm, of any greater than usual risk of harm for any child in the home. I think that many of us are parents here, and we know that stuff happens. And in fact, one of the things that's continually referred to in this case is an accident that happened at the Family Interaction Center with the older child while under the supervision of agency personnel, professionals who are trained to take care of children. This accident happened. I'm not saying that there was any fault there. I was saying specifically the opposite, that there is always some level of, it's not our job, it's not the court's job, it's not the agency's job to prevent all harm. Children are going to fall. Children are going to have accidents, and what I'm saying is that everything that in this case, as you read these transcripts, you will see that everything that involves the infant here and these two parents is an instance of normal parental-child interaction and behavior. There is no time when of unusual harm, of unusual risk to harm. While the caseworker speaks of concerns that mother could not take care of this infant, there is nothing she can point to that says that happened. She talks about the new father demonstrating control or trying to prevent her or her believing that she could not call the doctor without his authority. That is directly refuted on cross-examination, where in the evidence presented, mother was clearly calling the doctors, clearly making appointments, clearly keeping them herself. There is an instance that is referred to where there was an hour delay to try to find a ride to the hospital. Mother has transportation issues. I don't know that. But that there was no instance that did not lead to any harm to the child. That was dealt with within an hour, which is a reasonable amount of time if you do not have transportation to find that ride. And I don't want to call out the agency, but I think that there is an overstatement of the facts in this case. And I believe that is based on the prior fathers and the prior children's involvement in this case, and a hyper concern that is not the standard here. And I think that the parents in this case, and particularly with the different father, demonstrably able and willing to take care of these children and satisfy that child's basic needs and make sure that child did not come to harm without the involvement of the agency. And with that, I would also state that even if dependency finding was sustained under either of these subsections. The dispositional decision to remove the child from the home is contrary even to their own statements that the principal concern that they were having was that fast track was going to leave the home, which would remove the ability to supervise those children. And that with them out of the home, there would be no one to watch the child or to maintain this kind of control. That stated by maintaining a placement, a custodial disposition with custody to the parent and an order of protective supervision would have been sufficient and should have been the least intrusive and least restrictive outcome here, and in the best interest of the child and the infant who was with her mother, who was with her parents, and who was not at a risk of any harm. There was no clear reason to remove that child based even on their own complaint. To have that continued supervision and an entry order would have been an appropriate solution, which was argued for at the trial level.
You're in your rebuttal time, I just wanted to
Thank you very
keep
much.
going.
And so, with that, I believe that this agency abuse, or the court abuse its discretion in allowing, in placing custody with the agency. I will withhold the balance of my time.
Okay, thank you.
Thank you, Your Honor. Good afternoon. May it please the court, I'm Jacqueline Corda on behalf of Summit County Children's Services Board to urge this court to affirm the decision of the juvenile court, not only to find that the child in this case is a dependent child, but also to grant temporary custody of that child to Children's Services. Now, basically, there are really two questions before this court, as counsel articulated, but really it gets down to, firstly, why is this child a dependent child, and then why is temporary custody of that child in favor of the agency? Why is that temporary custody in the child's best interest? Under either subsection of 215104, either C or D, this child is a dependent child irrespective of how the parents may have interacted or how the child's siblings may have behaved. Because basically what you have in this case is you have a father who is working at least one or two jobs. He's out of the home most of the time. And so while he is out of the house, the care of the child, of any child, is left in the hands of mother. And mother herself, though, is essentially dependent. She's dependent upon father to make all of the decisions for herself and for any children that are in her care. And then she's also dependent on others, particularly her own mother, for transportation when emergencies arise. And specifically to her dependency upon father to make the decisions, this was something that was noted by many of the people who testified in the adjudication hearing, is that father, both parents, mother and father, have said and insist that father is the one who is in charge of this particular child. He is the one who makes all the decisions. To find out when the child's next doctor's appointment was going to take place, mother was going to text the father. And in an emergency situation where father may not respond back to mother in 20 minutes, that could be 20 minutes when a child is, for instance, if they fall, have a cut, that child could be left in a dangerous situation without mother feeling like she is able to take the initiative and make decisions and seek care for that child.
But doesn't the record demonstrate that she actually did take the child to the doctor and make appointments herself?
Yes, but there's also contradictory evidence in the record that, her father affirmatively cut her off of the list of people who were to be given information about the child's care. Mother was under the impression because of that, and because as a result of that she'd been excluded from the child's examination room during one of the appointments, that she was no longer authorized to do anything on behalf of that child. or to have the information for the child. So while that is going on, father has put up barriers essentially to mother either having medical information for that child or seeking care for that child.
I thought that had been remedied. Did I misread something?
Maybe I did, Your Honor.
I guess we'll both find out.
We shall indeed. But that's been the situation with this family, is that father is in charge of these things. And to refer to, well, I would like to refer to a specific portion of the record in the disposition hearing, but that actually wouldn't be appropriate. Father, the agency would have liked father to have gotten a parenting evaluation himself because of everything that came out during the adjudication hearing. But again, you have parents who are still insisting that father is in charge. Father had not wanted mother to work or to have friends, and so she didn't work, and she did not seek to have friendships. And yet mother...
Those all seem like, I'm sorry, but those all seem like marital issues.
They can be, unless they paralyze a parent from acting when a parent needs to be able to act.
Well, that's kind of a slippery slope though, isn't it? I mean, I think when you were arguing this, I think even though we're professional women, and no offense to the gentleman here, but a lot of times when it comes to doctor's appointments and so forth, father doesn't know what's going on. And mother makes all those decisions. And father, if he is the one to have to take the child, he needs to know where and how and when and everything else. So does that make father incapable of doing it?
No, absolutely not. What's dangerous in this case is because father is absent from the house for so many hours during the day, because he has to work to support the family in the best way he can, that the only person who is left in the daily immediate care of this child is mother. And unless she can act, unless she has the knowledge, and unless she feels like she can make these decisions on her own, irrespective and without input from father when it requires it, that can be a very big problem. And that was what the agency was trying to get at with the juvenile court, and I think that's what the juvenile court was looking at. It's who is supposed to be taking care of the child right here, right now, and can that person feel confident or feel like they have the ability to make that decision right there, right now. And that doesn't necessarily get into gender roles, or it gets into the practicality of who's there. So I hope that helps answer your question, Your Honor. But in addition, mother has also shown an unwillingness with children's services to try to find other ways to provide care for her children. And I like to refer to the instance where mother texted, I believe it was the caseworker, and said, one of the children has a fever of 103 degrees, what do I do? And the response was, well, get the child to a doctor now. I mean, 103-degree fever is one of those instances where it needs addressed in an immediate fashion. And for whatever reason why the child may have 103-degree fever, but the mother was hoping and relying on her own mother to provide transportation. When her mother responded that she was unavailable to immediately transport that child to a healthcare provider, mother then got in touch with the caseworker. Caseworker suggested get an ambulance to come and get you to and take you to the hospital. And mother provided reasons why she thought that would be impractical. For instance, well, they won't allow the other children to go with her. The caseworker didn't really think that made much sense to her, but eventually grandmother was able to come and take them to a provider. But what was alarming about that was that the caseworker had suggested to mother, look, you need to find alternative means to transport yourself and this child if an emergency arises. Kind of like, what are you going to do if you can't rely on grandmother if grandmother isn't available, or grandmother is ill, what are you going to do if that avenue of transportation or care is not available, and mother resisted that suggestion?
Is that all part of the reason the child was found dependent?
Yes. Yes, that actually gets to the dependency, and like I said, this child essentially is dependent because mother is dependent. She's dependent on grandmother, she's dependent on father, she's not acting independently for the welfare of any of her children.
Just thinking.
I could see, I thought there was a question brewing, so I thought I would
See
wait.
the wheels turning.
I can. But then getting on to why temporary custody is in this child's best interest. Again, this isn't a clear and convincing evidence standard to meet for temporary custody. It's just a preponderance standard as to what's in the best interest of the child. And for that, you look at the usual best interests of the child factors, such as the interrelationships of the child's wishes, and in a case of a child this young, you look to the guardian ad litem's opinion. In this case, the guardian ad litem thought that temporary custody in favor of the agency was in this child's best interest. And you look at the custodial history, the need for permanence.
How long had there been protective supervision in the home?
I believe there had, and
How long it was for?
I do not recall offhand, I'm sorry, Your Honor. I would like to mention that getting to some of the points that counsel had raised about the older siblings and that they had been returned to the house, that's not actually completely accurate. The oldest sibling had been returned to the home for a time period, was then subsequently removed, and the second oldest child was being considered to be returned to the home and was not. But I would like to refer, considering the temporary custody, I admit I think I'm jumping around a little bit, and I apologize.
Okay, I have a question for you anyway.
Thank you.
Consider, and let's just say that the subsection D with the older siblings could not be used. What does the agency see as clear and convincing evidence of dependency under C?
That's the condition or environment warranting the state in assuming the child's guardianship. And actually, everything that I've been talking about so far, I think gets to both prongs, both C and D, but it gets to C very strongly, because the conditions are that even though this child has not suffered physical harm or any emotional harm that we can discern, the child is young from her being in her mother's care up to this point, that's not a requirement. The child does not have to be harmed already for the child to be dependent or even neglected. But it's the danger that because mother is dependent herself upon father for all decisions and upon grandmother for transportation, etc., that the child that we have in this case today is in danger, or that environment endangers her and warrants the state assuming her guardianship.
Is it your position that mother is incapable or unwilling to contact father if a situation should arise where the child needs something?
No, because she was asked that, and her response was always, what are you going to do if an emergency arises? She said, I'm going to contact father. The problem with that was that when she was asked to contact father, say for instance to find out when the next doctor's appointment was, it took father 20 minutes to get back to her by text.
But that's not exactly an emergency situation, is it? Was there a reason to believe the doctor appointment was upcoming that day?
Or urgent?
No, but it was an illustration of why, for instance, if fathers weren't prevented him from looking at a text message or responding to a text message, why emergent care might be delayed inappropriately.
But what evidence did you have of that other than under 3-degree fever?
We don't have any evidence of that happening so far, but that's what we're trying to prevent happening. And that's the point, is that because there is a danger of that situation occurring, we don't want to have the child in that situation before we say that the child is dependent or neglected.
And I guess that gets me back to my original question. It just seems like, I'm sorry, but it does seem like there's a little bit of like gender stuff going on that, oh, well, wife shouldn't be so dependent on husband. That's unreasonable in the year 2020. Because if it was the other way around, I just don't see that the agency would be involved.
I beg to differ, Your Honor. I think that if the genders were reversed, the agency would still have the same concerns, because regardless of whether the parent who's providing the day-to-day care is a father or a mother, regardless of that person's gender, they still have to fulfill the same role, and that is to make sure that that child is cared for on a consistent and immediate basis.
Okay, but let me ask you another question. If father quit his job and stayed home, could the child stay home? You're essentially saying because father's not home, he works a couple, 3 jobs to provide for the family, she's relying on him, but she can't do this without him, he doesn't respond fast enough.
Given the dynamics of this family, and I'm just throwing out a hypothetical here, I can't actually say that this would be how it would actually work out, is that if, for instance, father quit his jobs, mother took the jobs, and she became the sole breadwinner in the family, so to speak, and father was at home, and because the way the parents have stated that father is in charge of this particular child, if he were the one at home making the minute-to-minute observations of the child, the care decisions, that this might not have arisen, or this situation might not have arisen. The child might not have been found to be dependent. I'm just saying that that's hypothetical because I'm not sure how that hearing would turn out.
You are over time. You had a question. I'll let you do your conclusion sentence, or you want to end up. Go ahead.
Okay, well, I'll keep it brief. The agency would respectfully ask this court to affirm as to both the dependency determination and the grant of temporary custody. Thank you very much.
About 3 minutes and 45 seconds-ish.
To address some of the things that came up, I think one of the major issues here struck by Judge Carr is there is no evidence of this emergency situation being ignored, or that there would be a requirement outside. We have an instance where mother texted to find out a doctor's appointment, and that was not a 911 call. That was not a situation where it was imperative the father respond immediately. A, don't know how long he would have delayed, or B, don't know how mother would have responded without a delay, though in a more emergent situation. I by no means, as this court knows, it's not a requirement that the agency wait until an actual harm occurs. That is black letter law, and I understand and respect that. But there has to be something more than mere conjecture that that this is going to occur, and this seems a leap beyond reason to suggest that we have evidence of an emergency situation that would be ignored when none has occurred. And in fact, we have evidence to the opposite, that all of his doctor's appointments were made, that mother, despite the representations of the caseworker, was actively involved and aware of when the doctor's appointments were and her ability to take those children to the doctor and to call for prescription and to address the needs. The issue of ranking the children is also unclear and a bit contradictory. I think you will find, talking with fast track workers, that father was not particularly actively involved in those. He was working, he was not taking a great participation in the involvement with his daughter at that time. this argument that somehow there was a ranking of these children and he was solely looking out for his own daughter and leaving the other two. Didn't look like he might have.
Well, the other two weren't in the home at the time of this attorney.
Early on in the case, I think the kind of fast track came in during the period where the one child, and the prosecutor is correct on the time, that the one child was returned fully to the home, but you'll see in the record there are numerous instances where all three children were there while fast track was there. At the time this case was filed, no, there was just, the children had to get their taken from them. But
I have one more question.
Please.
I ran out of time to even ask the prosecutor.
Sure.
What evidence, if any, was in the record in regard to mother's cognitive delays?
And there is, I believe, none. The only people called, particularly at adjudication, were the caseworker, who, and I don't believe there are any records submitted.
So
in
there's no
support of that.
evaluation conducted or
I
anything?
don't believe that there.
And there's no record
I
of
think
having
that
treatment? or-
the testimony is that she had an IEP when she was younger, as regarded, and I think that that's her own testimony, as presented by the caseworker. Mother did not testify at the hearing. And if that is my recollection, that's inaccurate, correct, I apologize.
No, that's okay, I'm just asking.
Regarding dependence, the mother, or the prosecutor struck on the words, a need for permanence. And obviously in any children's services case, the first goal is reunification with the parents. That's stated by statute. And the goal of the organization is to return the child to the home when appropriate. So if the need for permanence is to place the, and the permanent goal is reunification, I cannot understand how removal of the child at this point, as opposed to protective supervision where it would have been appropriate, is working toward that end. With that, I would rest and ask that this court